Welcome to the Money Study Podcast with Jim Bishopp. In this podcast, we bring lessons on personal finance to life, helping you achieve the dignified retirement you deserve. Jim will guide you through practical financial strategies and tips to manage your money during your working life and through retirement. Now, on to the show.
Hello and welcome to the Money Study with Jim Bishopp. Jim, good morning. How are you?
I am living the dream, Eric, like every day, buddy. How about you?
Yeah, I think we're living very similar dreams, my friend. I know that you brought a guest on the show today. I can see him right there. What's going on?
This is my good friend, Nolan Reidhead. He's the estate planning attorney that we often refer to and is our subject matter expert on all things estates for our firm and for lots of folks that we know. Been working together for 10 plus years.
Nice. That's quite a while. Welcome to the show.
Well, I appreciate being here with you, Jim. It's always good to sit down with you. We haven't done this in headphones yet, but it's good to be with you.
It is a little different, isn't it?
It is.
Your own voice sounds a little funny in your own ears, doesn't it?
It does.
Yeah.
It does.
Yeah, that's great. I know today you're talking about estate planning, and we're going to kind of go over some estate planning basics. I'm here to learn, so I've got lots of questions. But how do we start this off? What do you guys want to introduce to the audience? How do we introduce it to them?
Well, maybe we give Nolan a chance to just tell us a little bit about his practice, right? His practice is different than mine. He's, the Reidhead Law Group, I think. Mm-hmm. So tell us about your background and, where you're from and all the good stuff.
Yeah, well, I'm actually originally from Arizona. Yep. I was born in the Payson, grew up in the White Mountain area. I know you're very affluent, if you will, in the White Mountain area. Yeah. But moved to Tucson about 22 years ago. And started my own practice about 21 years ago and been practicing in the areas of estate planning and corporate and business law. Do a lot of estate planning, trust administration, estate administrations. Have wonderful staff that keep me in line. And so I just really enjoy being involved in this community, working in the estate planning area, working with individuals with their various ideas and goals and concerns that they have. And so really enjoy working with you, great professionals like you in the estate planning and financial planning realm. So Good to be here.
Good. Thanks for being here. It's a lot of fun. I got to tell you too, Nolan's, I think I say this a lot about Nolan, but he speaks English, not lawyer, which is a big deal, right? Because people, people really understand what he's talking about. His staff is really second to none. They've got a great responsive staff. I hope I can say this, but Nolan doesn't charge for introductory meetings or follow-up phone calls. It's not one of those deals where you hire an attorney and he just nickels and dimes you to death. So really appreciate all those things about his practice.
Yeah, years and years ago, I charged based on time billing, phone calls, emails, copy charges. But my staff and we just got so tired of keeping track of all the time. And people would call and say, Nolan, I'm on the clock. I need to get off because you're billing me. And so we went away from that. We do not charge for meetings with clients. We do not charge for phone calls and emails because a lot of people just want to pop you an email and ask a simple question and they don't want to get a huge bill for it. So we found that to be very worthwhile. It works well with clients and that's what we do. And also the review meetings, we do that complimentary with them as well. Which
is a big deal, right? Because the trust is nothing if it's not reviewed periodically. So
that's most super
important stuff. So we're excited
Jim,
to have him here.
How does it work then? The relationship between the two of you, how does that work and how do you engage clients from either side?
Well, so I'm obviously in the financial planning and investment business. So, we often have investment or financial planning clients, and in working with them, one of the questions we always talk about, because we've seen so many train wrecks along the way, is what is your plan for distribution at death, right? Do you have beneficiaries? Do you have a trust? Do you have a will? Just how are you handling that? What about your incapacity? And so through our investment work, we find these places where people are really uncovered or unprepared, and we send them over to Nolan. We will, I think, sometimes try to help folks understand where they want their money to go so that when they go see Nolan's office, they're prepared for that conversation. But that's really how that works.
On my side, if I meet with a client's referred or they come in and so I get a chance to sit down with them in the complimentary initial meeting, meet with them, go through their goals, desires, preferences, what some of their concerns are, talk about their assets and what they would want to do with them, whether they have minor children, whether they have other concerns. So it always comes up, hey, we have some funds here. We have parents just died. We have this inheritance coming in. We have this IRA, this 401k, these securities, these assets. What do we do with them? And it's always great to be able to say, Jim Bishopp, give them a call or work with him as far as beneficiary designations. Maybe it's a rollover of a 401k from a private company. And then as we plan with the client over the years and also upon the death of a client, it's so good to work with, like Jim's office to be able to work with the beneficiary rollovers or their distribution of assets, because otherwise they get bogged down, they get document driven. And so it's really good to have a team effort there in those regards.
We see their accounts all the time, so we know what they're doing. And if there's changes in their lifestyle, I mean, we meet with most of our clients, every 6 months, probably, maybe talk to them even more frequently. I'm not sure that's necessarily true with an estate planning attorney. They do their documents, and unless something has changed, they're probably not seeing them regularly. Though I do know you prompt your clients to make changes, but we see them all the time. So it's nice for us to sort of be on top of it and see errors or problems that might occur or might be problematic and get ahead of them.
Yeah. Nolan, to be quite honest, when I hear estate planning, estate and wealth planning, however you term it, I'm always thinking about a rolling estate. Horses, miles of fences and, an extra house or two on the property for the servants or whatever, right? How would you define an estate? Because I always think of it as a pretty lofty goal for most people, and kind of the basics of the estate planning as a definition.
If you are alive, then you pretty much have an estate. So if you're a walking, breathing person, then normally you will have sufficient assets that you want to protect. So one of the things we look at is we look at putting documents in place. So estate planning is basically the process by which we prepare for contingencies. So one issue is I want to make sure that I have a person designated to take care of my healthcare concerns if I become incapacitated. So that's really not a financial wealth issue.
Right.
That's just I need somebody that's going to step in and have a document in place that gives that person the ability to deal with healthcare issues, get access to information under HIPAA, the federal privacy law. And I want to avoid somebody having to go to court to be appointed as a guardian for me.
And frankly, I want to be able to name that person who's going to take care of whether I'm, alive, dead, or getting food or not getting food, and not have a court or a guardianship or a conservatorship or whatever mechanism that the public sector would assign to making that for me, right? So I'm making that decision.
Most definitely, because if I don't make those decisions ahead of time, then the court's going to do that for me, or somebody else is going to jump in to do that. So I have a document while am I competent now to make those decisions? But while I'm competent to make those decisions, I make those decisions ahead of time from a healthcare standpoint, your advance directives, financial power of attorney, living will. Those 3 documents are crucial regardless of the size of my estate. And so those are crucial to begin with. That's kind of the basic starting point from an estate planning standpoint.
Okay. That makes a lot of sense. And you said earlier that you want to talk to the clients about their goals and kind of what their hopes are. But what are your goals when it comes to creating those documents, creating an entire estate plan? What are the goals that you need to look at as an attorney?
So I want to talk to individuals and we just sit down and have a conversation about the healthcare power of attorney, the financial power of attorney, the living will. And so from a healthcare standpoint, we talk about who do they trust? Who's willing to be here in the event of an emergency, and who's going to be able to make the hard decisions as to whether to admit, Uncle Fred into a psychiatric hospitalization facility or administer healthcare needs, special needs in the event of dementia, or Alzheimer's, and so who's going to be willing to do it? Who do they trust? So that we can put the document in place, and so when the documents are triggered, we know the people there, we have their information, they can be contacted, they step in, and the process is seamless for the client to take care of their needs.
Yeah. And I might add another point there too. I've seen this a lot with other estate planning attorneys, right? So Nolan is really good at executing on the desires of the client, right? Because I've seen a lot of attorneys who sort of try to implement their own thoughts on, or their own biases on who should get the money, who's entitled to it, who's not entitled to it. That's not our role really, right? Our role is to execute getting the money to the person you want it to in the way you want it to get there, or to have your healthcare managed in the way that you choose to do it by the people you choose to have in charge of it.
Yeah.
And so not imposing our own bias, I think, is a big deal. Nolan does a great job of that.
All right. There's obviously there's a ton of documentation. There's a lot of moving parts to an estate plan, just from what you've introduced to me. What are those different documents that are involved in an estate plan, and what do they cover?
So the three primary, what are called advanced directives, there are three documents primarily. There's the healthcare power of attorney, which gives people of, let's say, my choosing, the power to make physical healthcare decisions, mental healthcare decisions, autopsy directives, organ and tissue donation directives, HIPAA authorizations. So that's kind of the first document, and it avoids having a healthcare power of attorney in place, avoids having somebody have to go to court to be appointed as a guardian.
Right.
So that's number one. The second is a living will, which governs the life ending decisions. And Jim and I, we've always talked about the situation with Terry Schiavo, lady out of Florida, who was unfortunately kept alive for over 14 years because she did not have a living will. And then the husband and the parents got into a legal battle. Having a simple advance directive, a living will, would have avoided that whole situation. And so the living will governs life-ending decisions. Then there's the financial power of attorney, whereby I can name people of my choosing to take care of my tax returns and my financial assets and pay my bills and take care of the governmental benefits. And that document avoids another court proceeding known as a conservatorship. So having a simple document in place can avoid the need for somebody to go to court, to be appointed by the court, then to go back to the court every year to give a report on how things are going.
Yeah.
So those three documents are crucial to start off the estate plan.
I would also say, well, I'll just interject with something here that, I hear a lot of people say, well, I can do this stuff on my own, and I can go to the internet and I can drag down a document and I can fill in my name and it's boilerplate. Well, you might be able to, but there are things in those laws and rules and really forethought things that I think somebody can help you with, a professional can help you with, like HIPAA language, right? So 5 years ago, how long HIPAA, probably more than that, but.
Well, and it came out originally in 96, but it really didn't have much effect until after 9/11. And then it came out later, became effective for the financial side well after 2012. So a lot of changes in the laws there.
Yeah. So somebody's not paying attention or doesn't really understand the law, or you download a dated document, it's really not going to hold any water. And I won't bore you with why HIPAA language or laws required an amendment or to be addressed in the powers of attorney, but they did. And if you didn't do it, you might as well have not had a power of attorney, because it's not going to work. Yeah.
Yeah. It just, like in Arizona, we just the legislature just enacted certain, I say just in the last couple of years, laws relating to pets. A lot of people have pets and they want to take care of their pets and have pet trusts and various things. They also digital rights, digital assets, cell phones, cashback and online flight miles, credit cards, and getting access to online banking. These various issues, you will not find them on your online power of attorney, and so it's the old saying: you get what you pay for. It would be like me trying to do my own electrical work. I'm going to get electrocuted. It's kind of that same concept.
Yep. Yeah. No, I think that's really important. I also think we can help you, or Nolan or I can, for that matter, help you just to make sure you're really consciously thinking about the people you appoint. So from my perspective, I make this joke all the time, but I see kids who inherit a pile of money and they, it's blown in no time at all. Right. So maybe you need to, things you might not think of on your own, but we might be able to prompt you to think about when they get the money. Should they get it all lump sum when they're 21? Well, I'll tell you for sure, that's not generally a very good idea. Yeah. Hope your kids are, well, I don't want to say better than mine, but really good kids, how about better than I was at 21? Because it'd have been gone at 21 if I had it. So things like that, just things to think about that I'm not going to get out of a do-it-yourself document.
Well, I'll tell you, Jim, you brought up kids, right? Nolan, Jim and I have had this conversation before. My wife and I have worked with children and families for a very, very long time. And the court side of things, right? That is scary. It is a very scary situation. And so I'm assuming part of this estate planning, part of those documents, you've got to be able to address the children in the situation, because I think, if I'm not mistaken, each state handles children differently as far as guardianship and, getting the courts involved. I just can't imagine anybody thinking, you know what, I think the government's going to make the best decision for my children.
Well, they always make the best decision, right? I mean, on everything.
Of course they do. Yes, we're nodding in agreement. We're nodding, smiling in agreement. Uncle Sam, we like you.
We're all smiling on that one.
Yeah.
Yeah. Yeah. So I'm assuming that's all addressed in an estate plan as well through other various documents, whether it's guardianship or whatever. Also, I'm assuming the financial side of taking care of those children for whatever lifetime they have, with their guardian and then into adulthood. I mean, that's got to be pretty complicated.
It does. And so it's crucial to have the initial estate plan set up properly. And when you deal with kids, what we do is another document is the will. There's a will. The will is kind of the dinosaur of estate planning, but one thing the will does, especially for minor children, it designates guardians. And it's crucial to appoint people they're going to act properly in that guardianship role. One thing that I find people do is they name my brother and sister-in-law as the guardians, as co-guardians. Well, what if they get a divorce?
Right.
Well, you have a divorced couple acting as guardians for your children. And so it's just crucial to not only to talk about those issues and maybe cut off the problem ahead of time, but it's also to have the reviews. Jim, you talked about the reviews are crucial to talk about those issues and make sure the documents are kept up to date with those issues. And so the laws change state to state. You may have a couple that moves here from California or some other state that we need to look at the documents and see if they're up to date with Arizona law and make sure those type of issues, especially for minor children. And then from a distribution standpoint, we definitely want to talk about when is it appropriate to distribute the assets to a minor child. Yeah. And boy, that's an important discussion because they may have money coming from non-retirement assets, whether it be a home, whether it be real estate, whether it be just bank accounts, securities. They may also have money coming from a retirement plan, a tax-deferred plan or life insurance that has tax ramifications. So do we want it all to come to the child at 21? That's a scary proposition.
Yeah.
And what about if there's some special needs?
Right. That's a big one, right? We're going to have a whole other show on special needs trust and special needs planning because it's a big deal, right? I mean, if somebody with special needs gets some lump sum of money from an estate, they can be disqualified from receiving, any other public funds, right?
Right. Most definitely. So we have to look at, will there be a need for governmental benefits in the future? Right. Because of an outright inheritance can disqualify that child. You may have parents without any children. Do we look at their parents? Well, the parents may be subject to Medicaid or other special needs there. Do we look at siblings? Do we look at the crazy Uncle Joe that they want to include, or charitable organizations? Yeah. So a lot of discussion, a lot of input goes into the formulation of the documents. But it's crucial to have those reviews. We don't meet as often as you do, Jim. We usually meet about every 2 to 3 years. Yeah. But we also allow the free phone calls and the complimentary emails because those issues come up a lot.
But because we work together, if I identify a problem or an issue or an area of concern, maybe I don't even know how it should be or what, I can pick up the phone, and Nolan and his team are outstanding in helping us in that way. And I think working together, having a collaborative effort is a great thing. Helps a lot.
It helps. It's tremendous.
Yeah.
And especially not only now, but also upon death or when something is triggered. It's a huge benefit.
Yep. No, that's spot on.
Yeah. Jim and I have also had conversations about past mistakes, right? I think one of the biggest teachers for me has been past mistakes. I like to learn them from others when I've seen somebody else make a mistake.
Always a good idea.
But I've made my share, right? As we all have. But give me some examples of... Yeah, give me some examples of mistakes people have made besides the going on the internet and trying to do it themselves, because you can't ask questions back and forth. I don't care how good Google is or Alexa. Right. You just don't have that relationship or the conversations that you should be having. What other mistakes have you guys seen? Not to scare people, but things that they need to avoid.
I was telling Nolan, I'm going to write a book when I retire. I'm going to go pick his brain and the things I've seen. And it does not take a lot of money to create real strife in a family. I mean, we literally had fist fights in the parking lot over $3,000. It's mind boggling, but you probably got better stories than I do.
It is amazing what inheritance does to people. It just, their minds just all of a sudden just go crazy.
Oh yeah.
But it's dealing with divorces. Jim and I are currently working with a situation where this individual passed away. Fortunately, we did the estate planning prior to his death, because he had just divorced his wife, had a minor child. And if we hadn't have put documentation in place, the funds would have gone to most likely under the control of the ex-spouse. And I'll guarantee you, it would have been gone by now. It would have been gone by now, not for the benefit of the child. And so we put proper planning in place, a trust in this case. and it was protected, it was secured. Jim, through his great advisory work, was able to protect those assets, and now we have a minor child who's an adult now, going to college. That money's there for educational purposes, and it's protected. That was some good planning, but I'm glad we were able to do it prior to his death.
Me too, and I'll give you another prop there, because the ex-spouse mother of the minor child really contemplated heavily taking some litigation against us or against the estate to try to get that, get to claim some wrongdoing. And the estate planning was so tight, they just gave up and rolled over, and that was the end of it. So another reason not to do it on your own on the internet, because you just don't have that kind of backing.
Yeah, quite true. Quite true.
I'll jump in with one for Nolan. What about the difference between just a trust and a will, right? To his point, a lot of people think trusts are, Rockefeller kind of things, only the super wealthy need a trust. I'm just going to do a will. But
yeah, one of the primary reasons for having a trust versus a will is that a will does not avoid probate, the process by which the court has to get involved with naming someone to administer an estate. Right. Or distributing the assets to the heirs or the beneficiaries. And so the will doesn't avoid that process. The will just goes into the court system. The court approves the will, appoints the person as the executor, and then oversees the administration of the probate process, which in Arizona and many states, like in Arizona, 10 to 14 months. In California, you're there for years.
So I can't get my money if I'm named the beneficiary for 10 to 14 months until the court sorts that out. If I have to go to a probate,
you may not get your money until the executor has the power and has gone through certain creditor periods and various issues. So,
and aren't I subject to somebody could come back. You actually literally have to post the probate process in the paper, right? So some guy could come back and say, that Bishopp clown sold me a lemon of a car and I want $5,000, and bam, we're off to some kind of probate court proceeding to determine whether that's viable or not.
And the probate process is all public record.
All public.
And we have to publish a notice in a newspaper once a week for 3 consecutive weeks. And then creditors have 4 months in which to bring a claim against the estate. So we're waiting.
Right.
It's just in limbo and we're waiting. And it's just...
Even if nobody has a claim against the state, we're still waiting to give them a period in which they can come and say, I owe money.
Yeah. And we find, in Arizona, Tucson, we have a lot of snowbirds.
Yeah.
We have folks with homes here in Arizona, homes in Minnesota or some other state. So they're looking at 2 probate proceedings, one in Arizona where they're domiciled, they have a home here, and one in Minnesota where they also have real estate, because Arizona does not have jurisdiction over that property in Minnesota. So they may be looking at, I had a case where we had 4 probate proceedings. So we not only had one attorney, that's bad enough, Jim, but we had 4 attorneys dealing with that case. And so it was a nightmare, years. And so a trust is a document. A lot of people hear of trust, they think of this elaborate, only document for wealthy individuals. Right. See, the probate level in Arizona is $75,000 for personal property or $100,000 of equity in real estate. So it doesn't take a whole lot to get to those levels.
You have to be under that amount to avoid a probate if you have, and a will is a guaranteed trip to probate, right? I mean,
pretty much, unless the assets transfer to others outside of the will.
Beneficiary.
But many people have not done that, have not taken those steps, and so a probate is going to avoid the court process if done correctly. Yeah,
that's a big deal.
So are you saying if the government steps in, it slows the process down? Sorry.
Can you imagine that?
When it slows it down?
What?
No, it's they're good at it, and they always do things better than the private sector. So yeah.
Well, and another thing is unfortunately you'll have now all attorneys, as we know, are honest, are just charitable in nature and all that.
Absolutely.
But the thing of it is many attorneys will just draft a will because they know that they're going to get the probate proceeding on the back end.
Right.
So it's a way to get not only fees up front, but also on the back end, which I think is a huge disservice to.
So at the end of the day, right? At the end of the day, not doing a trust in many cases might literally cost you more in the long run, because you both have the cost of the will and other supporting documents, plus the cost of the probate on the back end when something happens.
Well, the probate by far is more expensive on the back end. It's just because usually in a probate proceeding, things are done, they're billed on an hourly basis, time billing. And it's a lot more expensive, a lot more time, and so it's a much more lucrative proposition. But it's a disservice to the client.
And Nolan can check me here a little if I speak out of line, but I say the only reason not to do a trust is a few $100s, right? Because a will is going to cost me whatever X number of dollars, and a trust is going to be a little bit more. But that's the only downside to a trust, because everything else can be controlled through a trust much more quickly, efficiently, expeditiously, right? I mean, just in my mind, I mean, I guess there are cases where a trust doesn't make sense or is not necessary, and you'll advise to that end. But for most of us, I think a trust is a much better document.
For the most part. And the beauty of a trust is either a single individual or a couple are going to name people that will step in automatically without having to go through court to administer the estate and the assets, both during lifetime, but then also during disability.
Yeah.
So a trust is a lifetime document, whereas a will is a upon death document. And then the parents or the individual are going to be able to designate how the assets are to be distributed, how to protect the minor children, how to protect the children that have certain disabilities, how to protect the child against maybe a divorce, maybe bankruptcy, maybe litigation, to protect the minor child from himself a lot of times. And then, so it spells all that out. And then upon death, it's just a matter of usually getting the death certificates, and then we're off and running. And
then if you want to make a change to what you said in your, Johnny was not behaving, but now Johnny's back in the game and we like him and we want to take some of these restrictions off, it's a change to one document. You go change that singular document, amendment is filed, or however it needs to be administratively handled, but it's handled. And then that changes the whole picture in one document.
So that's fantastic.
A simple way to do that. So.
Right.
All right. I know we're running low on time, guys, but I don't want to leave here without this last question. What is the process? How does somebody start this process? They've been listening to this podcast going, okay, that makes a lot of sense. I don't want to burden my heirs with probate and all the other things that could come with it. I need to take a look at what I need to do. How do they start the process, guys?
So from my standpoint, we always like to, if a client were to call me or to call Jim, I would work with Jim to facilitate that. But what we like to do is we would normally send, if I get an email or a phone call from a client, my staff will answer that phone call, and then usually start out by sending a document back to the client, usually a questionnaire. Yep. It allows the individual and the couple to kind of sit down and think about who they want to designate for healthcare purposes, burial versus cremation, just kind of a starting point. And then we have an initial consultation against a complimentary meeting, and we review the questionnaire, we review their goals, review their desires. We then say, hey, you have some, retirement plans here. We need to look at and work with Jim with respect to the beneficiary designations and those issues. But it's kind of it's initial consultation and initial starting point to get the information, because a good estate plan is always based on good information and good planning. And then we have that information. And then we have a game plan. We designate a game plan. And then we schedule a closing appointment, and it's a second meeting or third meeting, depending on the meetings that we need to get the plan right. And then that closing appointment is where everything is signed, notarized, witnessed, and then we move on from there.
Yeah. Essentially the same process for us. If we find or we have a relationship with someone who needs an estate plan, we'll send them Nolans, really, his questionnaire. They'll complete that thing. We might help them think through what those, who the who's who and what's what and when's when. And then they go to Nolan and prepare the document. And then once we get them back, we make sure that the trust is named where it's appropriate, or the beneficiaries are appropriately named, and then try to make sure, because I would say, correct me if I'm wrong, but one of the biggest places people fall down is in funding.
Oh, most definitely.
Right.
Yeah. The funding, the way that a trust avoids probate. So if I have an asset in my name only and I die and the deed lists my name only, well, that asset doesn't automatically go to anybody upon death. So therefore it's subject to probate.
Yep.
Well, we put the home into my trust, so the trust owns it, but I fully control it. And then upon my death, that my successor trustee steps in and it can administer that home free of probate immediately. So we have to make sure that the bank accounts, the real estate, the assets are titled in the name of the trust. A lot of law firms will not do that. A lot of advisors will not do that. And so it's good to work with advisors that will work with the clients to retitle the securities accounts and the CDs and the bank accounts. We'll make sure the beneficiary designations are correct on life insurance and IRAs and annuities, and make sure all that's set up, vehicles, personal property items. And then once all of that's done, then it's just a matter of reviewing it and monitoring it going forward.
And keeping an eye on it, right? Because I often see people who will buy another asset, don't put it in the name of the trust, or don't properly title it. And then, it's outside, and that piece of asset has to go to, a particular asset has to go to probate to get solved. Even though I went to all the trouble of doing this, I didn't, putting together a proper estate plan.
Well, and one prime example is I had a client years ago. We put the home in the trust. And then when all the mortgage interest rates really started to go, they went back to refinance their mortgage. Well, at the time, the bank took the home out of the trust. They were supposed to put it back in the trust. And the title company just inadvertently put it in the wife's name only. Then the clients didn't know. They'd signed all those documents. They went on a trip to California. On the way back, the wife died with that home in her name only. So we had this backup will that poured it back over into the trust, but without the proper planning, because it was a second marriage, and we would have been in trouble had we not had the proper planning in place. So just keeping it up to date.
We could do this for hours, Eric. I got one more that I find all the time. But what about elderly folks, or maybe not even elderly, but elderly folks that love to put property in joint tenancy with their children? I see that all the time as their way to, bypass the probate process or make sure it goes to little Johnny.
That's a bad idea, but you see it all the time.
All the time.
So what they'll say, in order to avoid probate, I'm going to put my son's name on my bank account.
Right. Or my house.
Put my daughter's name on my home with me. Well, inadvertently, they're doing two things. Number one, they're giving the home in the entirety to the son or the daughter without thinking of the other children, because the home automatically passes to that child that's named on the deed or the bank account. Number two, I had a situation where the wife said the bank told her to put the son's name on her bank accounts to avoid probate, which is true. It'll go to the son.
It will, yeah.
But the son all of a sudden got in some legal issues, had some judgment against him. They went after the accounts because the son's name was on the account.
Even though it was never Junior's, it was always Mom's.
Yep.
But the court doesn't care. The lawyers, they're going to go get it.
And they went after, took half of the money in the bank accounts, and there's nothing that the mother could have done.
I've never seen it personally, but I've heard horror stories about homes getting attached by creditors, where little Johnny got in trouble. Somebody got in a car accident. Somebody fell in his house. May not even be his own, really a fault, but he has a judgment against him. They attach the house with a lien.
Yeah, you're subjecting the son or daughter's creditors to your assets by putting your son or daughter's name on the assets themselves. And so there's a better way to do it.
Yeah, don't do that.
Yeah. Wow. Well, Jim, before we even started recording today, you said you have some resources that you're putting on the website for the listeners.
Yeah, you can, when you pop onto our website, there's a drop down right away on sort of one of those flying deals on the website. And there's a piece on estate planning that might be useful, a white paper. You can grab that thing and just give you some good reading material and some base information, so you're well informed when you go meet with Nolan or our team.
All right. And one more teaser. Jim, why don't you tell us a little bit about that next podcast?
Yeah. So Nolan and I are doing one more. We're bringing in Tucson Firefighters Association, because we're doing some work collectively with them to provide estate planning services to their membership. So stay tuned for that. Particularly those in public safety will really enjoy that one, I think.
Yeah, absolutely. Guys, thank you so much. Anybody have any closing thoughts for today's podcast?
It's good to be alive, Jim.
Amen, brother. Yep. Glad to be here. Thanks, Eric. Appreciate all your time and your help, man, your expertise.
Thank you.
Hey, you bet. No, I enjoyed it. I learned something every time we get together. Awesome. I thank you both. And of course, our last thank you goes to you, listening audience. Thank you for tuning in and listening to The Money Study with Jim Bishop. If you have not subscribed to the podcast yet, please click the subscribe now button below. This way, when Jim comes out with a new podcast, it'll show up directly on your listening device. This makes it much easier to share these podcasts with your friends and family. And again, this is a great one to share. People need to know this. If you've got your son's name on your house, get him off of there. I don't know. Right. Or seek advice. Don't just do it by yourself.
That's right. Yeah.
Seek some advice. Again, thank you for listening today. For everyone at SGI Financial Services Incorporated, this is Eric Johnson reminding you to live your best day every day. And we'll see you next time.
Thank you for listening to the Money Study Podcast. Click the subscribe button below to be notified when new episodes become available. The opinions expressed in this podcast are those of the speaker and/or the guest, and may not necessarily reflect those held by Voya Financial Advisors. Comments concerning the past performance of monetary instruments, investment indexes, or international markets are not intended to be forward-looking and should not be viewed as an indication of future results. Investment advisor representative and registered representative of, and securities and investment advisory services offered through Voya Financial Advisors, Inc., member SIPC. SJI Financial is not a subsidiary of, nor controlled by Voya Financial Advisors.
Nolan Reidhead and Reidhead Law Group are not affiliated with Voya Financial Advisors. Neither Voya Financial Advisors nor its representatives offer tax or legal advice. Please consult with your tax and legal advisors regarding your individual situations.